Slaying Sunna. Abu Ishaq al-Shatibi's concept of Bida in Al-Iʻtiṣām. McGill University, 1999, Montreal, Canada. Asif Saifuddin, Jahar, Chapter 3, B. Bid'ah and Istihsan, Religious Innovation and Juristic Preference. Like Maslaha Mursala, Istihsan, juristic preference, generally is accepted as a subsidiary source of law in Islamic jurisprudence, though its position is still opposed by some jurists, such as the Shafi'is. What is important for our purpose, however, is Shatibi's view on Istihsan in connection with Bid'ah. For Shatibi, Istihsan, in terms of its literal meaning, i.e., to presume something to be good or bad, was utilized by the people of innovation as their argument. Unlike pure Istihsan, which is somewhat arbitrary in determining what is good and bad, the Shari'iyya leaves no doubt about its position. Any assessment of good or bad, or pure Istihsan in Shari'i matters, which is not based on a certain indicant, constitutes innovation. Bearing this arbitrary use of Istihsan in mind, Shatibi nevertheless categorizes it as a legitimate source of law applied in cases where the text is silent. For him, the use of sound Istihsan, juristic preference, is not based on one's feelings or speculative reason. On the contrary, Istihsan espoused in Islamic jurisprudence must be seen from the perspective of the objective of the lawgiver. The validity of Istihsan, according to him, is recognizable in cases where there is a duality between relying on necessity, daruri, on the one hand, and using qiyas, ratio legis, on the other. Exclusive reliance on the latter in a given case may, however, lead to hardship, and therefore is to be avoided. Instead, Istihsan should be used. For example, the araya contract, by which unripe dates on the palm tree are bartered against their value, calculated in terms of edible dried dates, is considered lawful. If it were left to qiyas, it would be unlawful, but due to great exigency and hardship, the solution by Istihsan makes it lawful. In this particular case, Istihsan promotes a particular maslaha in maintaining the universal dalil, the universal indicant. The validity of Istihsan as a legal principle was also defended by Ash-Shirazi, who died in 476, commensurate with 1083. He selectively accepted Istihsan as long as it was approved by an indicant, and when the use of qiyas was less than certain. He, however, rejected Istihsan when deemed to be a limitation of the illah, ratio legis, by a dalil, takhsis al-illa bid-dalil. Apologies, no Arabic given. The former is illustrated by an example of a person who out of forgetfulness proceeds to eat something when he is supposed to be fasting. Qiyas, ratio legis, dictates that the fasting would become void, for the fundamental consideration in qiyas is that food has entered his body, whether intentionally or not. This judgment is, however, abandoned on the basis of a prophetic report, which declares fasting to be valid if eating was done as a result of forgetfulness. This prophetic report is thought to be preferred because it takes into account a text that would not otherwise have been employed in qiyas, and which results in a different rule. The above example is regarded by Shirazi as a sound Istihsan, given the weakness of qiyas in this case. Shirazi, however, as we have seen, objects to limiting the illa by dalil. Istihsan in this case is not tolerated and must be regarded as unsound. In addition, for him the use of Istihsan, juristic preference, is based on the prophetic report, quote, what Muslims deem good is good for God, good before God. مَا رَآهُ الْمُسْلِمُونَ حَسَنًا فَهُوَ عِنْدَ اللَّهِ حَسَنٌ. Apologies, no Arabic given. The report, according to Shirazi, connotes the goodness which may be identified through the consensus of ulama, not individual preference. Any justification by rational preference without a dalil is in error. Qiyas, accordingly, is only to be used as a tool if no explicit text pronounces on the relevant matter. A similar argument which rejects Istihsan when it involves limitation of the ratio legis, takhsis al-illa, is also made by Sarkhasi, who dies in 490-1097. He cites the case of the difference between predatory animals and predatory birds. The beak of the latter is analogized as bone, which therefore cannot transmit impurity to the food. The former, however, use their tongues when eating and consequently transmit impurities to the food they consume. This example, Sarkhasi says, is not to be regarded as takhsis al-illa, the limitation of ratio legis, but rather as a preferred qiyas, al-qiyas al-mustahsan. This is because he concludes the use of istihsan follows the Quran, the Sunna, and the pious predecessors. Stay tuned for many more parts.